So good evening and welcome to this marvellous and actually most joyous event, a celebration of Sally's book. My name is Sarah Biddulph at the University of Melbourne, and I'm sure that you all have a printout of the event overview, and so I won't read it all out word by word. But what I'd like to say is that Sally worked for a long time in the Asian Law Centre as she was completing her PhD. And has been a long and very valued member of our community. Before we start the proceedings, I'd like to acknowledge that we're on the unceded lands of the Wurundjeri people of the Kulin Nations. I pay my respects to their elders, past, present and emerging, and acknowledge that we have a long way to go for reconciliation. So this evening's event, we have Professor Pip Nicholson, who will give a discussion of the book and launch it, I suppose. We haven't got a bottle of champagne. I don't know how you launch books, you bash them or do something else to them, but launch it, she will. And then that will be followed by Sally having an opportunity to speak to her book and to Pip's comments for about 10 minutes. And then we're delighted to ask Professor David Chandler, who was Sally's other PhD supervisor, to say some words before we throw the floor open to questions and answers. So let me introduce Pip Nicholson first. Pip is Deputy Vice-Chancellor, People and Community at the University of Melbourne. She was appointed to this position in April of 2022. And before being appointed to that position, she served as Dean of the Melbourne Law School from 2018 to March 2022. And prior to that, served as the Director of the Asian Law Centre from 2013 to 2017. So for over 20 years, Professor Nicholson's research has focused on the Vietnamese legal system and comparative approaches to development aid. She's a former barrister and solicitor of the Supreme Court of Victoria and the High Court of Australia. Her professional experience spans commercial law, legal aid, international consultancy, and a focus on development aid in Asia. We lost Pip up to the Central University, and so we're very pleased tonight that she can come back to her rightful home and engage in this wonderful event. Dr. Sally Low first visited Cambodia as a volunteer in 1993, where she witnessed the last months of the mission of the United Nations Transitional Authority on Cambodia. She worked for several decades in overseas aid sector, focusing mainly on Southeast Asia and always maintaining an interest in Cambodia, in particular issues of gender equity. In 2008, she contributed to research regarding the impact of broad anti-human trafficking legislation on the human rights of Cambodian sex workers. For over 10 years, she served on the board of the Women's Information Centre, a Cambodian NGO based among female garment workers. She has co-authored papers regarding the impact of donor assistance on the legal sector and LGBTQI rights in Cambodia. She holds an LLB from Macquarie University, completed her LLM by coursework and PhD at Melbourne Law School. I might add that she also helped with editing the Handbook of Human Rights in China, which went from huge to unmanageably enormous. And we're really grateful for her for insight and her very accurate, precise and careful reading and thinking about that, which helped to make the book something that it is. So let me now invite Pip to say some words about the book.
Thanks. And let me also acknowledge we're on the unceded land of the peoples of the Kulin Nation and pay respects to elders past and present. And thank you, Sarah, for such a kind and generous introduction. And the first correction to the record that I want to make is that I was the other supervisor. The august supervisor in the partnership was Emeritus Professor David Chandler, who's very generously joined us this evening, and in whose company I think both Sally and I are delighted over the period of the candidature. One of those few doctoral candidatures when you're in no rush to see the end, because there's such a joy in the supervision and in the meetings that we had together. Sally did first visit me, I think, to propose that you do a thesis in 2012. So it's wonderful to enjoy not only the completion, but also the publication of such wonderful work. And as I mentioned, for David and I, the relationship and working with Sally was an absolute pleasure. David used to routinely say, and such excellent writing, and such excellent writing. And I did remember a little bit of that last night as I was dipping into the book again. And I think across that time, our enthusiasm for your project grew, and in my case, my introduction to the legal system of Cambodia and its legal issues was thoroughly expanded. I note I spent the first 2 years of my life in Cambodia, so it was a particular personal pleasure to supervise this thesis. Colonial lawmaking in the French in Cambodia focuses on what is and was, and with the exception of your work, remains a very neglected aspect of the French colonisation of Cambodia and of Cambodian legal history. Sally diligently and insightfully mined colonial archives, both in Cambodia and France, and was carefully counselled, if I recall, David, about how to navigate the working hours of the archives in France, which can be a little unpredictable, and there is a very firm lunch break. But the work produced an original socio-political study of the role and impact of colonial law in Cambodia. Sally, in her work, explains that the French claimed, not unsurprisingly given the claim was widely made in their colonies, but they claimed to have reformed and reimagined law and its practice in colonial Cambodia, for example, by separating out judicial and administrative powers, rationalising laws and courts, and introducing a range of guarantees for Cambodian litigants. Without spoiling the reading of the book, Sally argues that these claims needed to be assessed in light of the colonial French domination, and indeed that's what she then proceeded to do. And she certainly challenged the notion of idealised French justice. I will ultimately talk to your conclusions, but first I wanted to offer my own précis of the work and its arguments. So the French established a protectorate over Cambodia, and I don't know this audience well, so some of you know this very well, I assume, and for some of you it may be less well-trodden territory. The French established a protectorate in Cambodia in 1863 and later incorporated it within the broader colony of Indochina, along with Vietnam and Laos. And my connection with Sally's work is the interest that I've had over many years in Vietnam. Although I haven't looked at the colonial period, and certainly not in the way Sally has. Practically, Cambodia and Laos became independent in 1953, while the Vietnamese communist-led forces defeated the French army in 1954, and many of you will know the sorry tale of the ensuing military conflict in Vietnam for a further 20 plus years. For the French, Cambodia was less important than the northern and southern regions of Vietnam. Sally asked to what extent French rule delivered the noble achievement of French law, a term adapted from Guha's work when writing on India. She concludes that the colonial legal legacy indeed lacked much, though not all of the liberatory potential of Western law. But for me, and I think for many, the most original aspect of this book is its detailed study of the myriad factors and exchanges that shaped colonial law in Cambodia. Mutual incomprehension arising from two very different cosmologies of law, power, and justice. And I've always found the term cosmologies, which Sally uses deftly, a little dense. So I offer for you a definition of it, which I confirmed with Sally. I wouldn't seek to offer you my own. But here, looking, in other words, at different understandings of what the law was, its derivations, its methods, and its justifications. So not merely at its text, but the way it circulated and operated. She looked at notions of civilization that were blindly Eurocentric, but also altruistic, divergent personal and political ambitions, and of course the economic and political requirements of colonial rule, all of which affected the making of colonial law. Central to Sally's approach is the understanding that although the bargaining power of the Cambodian elite was severely constrained by their colonial masters, it was not extinguished. Competing interests were also at play. The elites, especially those that learnt French, acted in effect as gatekeepers between the colonial authorities and the non-elite Cambodians. The latter largely remained a mystery to the French. So in 1916, for example, when peasants across the country began to protest against colonial taxes, the French both suspected Cambodian elites of instigating the unrest, but then also relied on them to suppress it. Ultimately, one of the Cambodian kings, Sisawath, would and could put an end to the unrest. This leverage, and I think you describe it, Sally, as codependence between the colonial apparatus and the Cambodian elites, facilitated brutally pragmatic concessions on both sides, none of which did much to advance justice, or put in other words, inevitably compromising justice. As Cambodia was a protectorate, rather than directly annexed as a colony, French rule was formally indirect. So the colonial apparatus depended on the consent of the king and the elites that served him. So therefore, when they began to reform the Cambodian courts and judicial procedures, which had indeed become corrupt and exploitative, the French claimed to be modernising pre-existing Cambodian legal texts rather than replacing them. They in fact gradually introduced and imposed new criminal codes and civil codes that drew directly on French law with some concessions to Cambodian law and customs. They rewrote Cambodian law and created embryonic Western-style legal institutions, but they did so in the name of the king, the Khmer tradition, and in the process they embedded notions of the monarchy as the semi-divine source of law, with important consequences for Cambodia's constitutional law and its political trajectory in the early years of independence. So the structures that were laid through this period had enduring consequences. As in most of the colonies, the French used ethnically divided jurisdictions across Indochina to impose their authority and to establish colonial hierarchies. In Cambodia, these jurisdictions were shaped to a remarkable extent, and Sally carefully details this, by competition between the administrative and judicial arms of the colonial apparatus. Successive French résidents supérieurs, or colonial governors, set out to minimise the number of French judges in the protectorate. And as a result, Indigenous courts, albeit structured along French lines, and applying the French-inspired law that Sally has carefully set out in the book, became the most important judicial institutions in the country and the main legacy of colonial rule. This contrasts sharply with many other former colonies, which adapted legal institutions formerly presided over by colonial judges. So a point of difference, carefully mapped out across the publication. The French claimed to have established an independent Cambodian judiciary, but their understanding of the term independent was indeed limited, as they closely monitored the judges and also at times advised on the outcomes of important cases. Legal training for the judiciary was inadequate, and from 1901 onwards, the French also repeatedly thwarted attempts to form a robust and autonomous profession of lawyers. There were adjutants for change and reform, which you discovered across the publications and the archives, but their opportunities were highly constrained. Continuing this account into the period immediately following independence, Sally then goes on to interrogate the post-1954 Cambodian legal arrangements, arguing that the protectorate's heritage was highly dependent, only partially secular legal system. So a highly dependent and only partially secular system. This played out in the early stages of independence when King Norodom Sihanouk built on this legacy to argue that the constitution was his to change, and later abdicated the throne to become a nominally secular politician while continuing to build on the royal cachet and the legacies he had built around its authority. So our understanding of Cambodia's complex legal past is inevitably but beautifully enriched by Sally's decision to undertake a thesis that focused on the French colonial system of justice and its early legacies, and then to share it with you all as a book. And I launch the book into this room and into libraries and hands across the world, and I invite you to read it and to debate its findings, but it is a major contribution to our understanding of Cambodia, and I thank you for doing it. And I think Sally's going to say a few words.
First of all, thank you to Pip for those very kind words, and thank you for being one of the supervisors of my thesis, and thank you also to David, Professor David Chandler, who's here tonight. I was blessed in my thesis supervisors, and I remember feeling that way when I talked to other PhD candidates who didn't always have the same experience. Not that the law school's supervisors aren't of a very high level, but sometimes you just don't gel. And Pip and David and I gelled, I think. We're all very different and we came from different perspectives, but I think we all learnt to respect each other, and I certainly learnt a tremendous amount from both of them. Thank you also to Sarah and Catherine Taylor from the Asian Law Centre for organising this event tonight. It's very generous of you. I haven't actually been around the Asian Law Centre very much in the last couple of years because I'm more or less retired now, but my time here was wonderful. One of the great privileges of my life was having a little carrel here on the 7th floor. Anyway, Pip's given, I think, quite a good summary of the book, an excellent summary of the book. And actually, she had shown me what she was going to write, and I had forgotten some of it, and I may be repeating a little bit, but anyway. One of the striking things about European colonisation I came to realise when I was researching this book particularly the colonisation that took place from the mid-19th century onwards, is just how important law was to that process or those processes. Colonial Cambodia was a very lawful, if not always a law-abiding place. I'd categorise the role that law played in three ways under French protection. First of all, that international law, the 1863 Treaty of Protection, established France's claim to be the sole colonial power with the right to intervene in Cambodia. And it also, looking inwards, the Treaty of Protection established and authorised France's presence. The fact that Cambodia was constituted as a protectorate and not a directly annexed colony was also very important in defining the way that law was used, but also in defining the relationship, as Pip has outlined, between the colonial authorities and the and the Cambodians, particularly the Cambodian elite. French Indochina, as you can see from the map, was composed of 5 regions, which today constitute the countries of Laos, Vietnam, and Cambodia. Each of them had a different status in international law, and that status also in some ways affected the way that law was developed in each one. Each one was different. As Pip said, a lot of my book focuses on the way in which law was made in Cambodia. I argue that although they tended to use certain methods in all of their colonies, the French didn't actually have a blueprint for the way they did colonial law. Rather, law tended to unfold in different ways in each of the 5 regions of Indochina. I don't ignore the economic incentives for colonisation and the broader political context that also affected the way law was used and developed. But I do focus more on the what someone might call the contingent factors. And going through the archives, I've tried to glean some of the day-to-day interactions between Cambodians and their French protectors, and also some of the tensions amongst different arms of the French administration and later tensions within the Cambodian elite too. So in taking this approach, I was inspired by what I found in the archives, but also by an Indian legal scholar called Upendra Baxi, who wrote many things, but one of the phrases that stuck with me, he talked about transactions between coloniser and colonised and shifting coincidences of interest. And I think that those words really summed up for me what I saw taking place, or what I saw had taken place in the archives. So just to speak a little bit about these 2 themes, the importance of law and also the contingency of law, I'd like to concentrate on one incident that took place in 1941, when a lawyer called Pen Nut wrote a set of complaints, basically, about the legal system as it had been developed under the French. This document is particularly important because it's actually one of the few archives where we find a Cambodian saying frankly what they thought about the whole thing. The rest of it's all written by the French overseen by the French. So Pen Nut wrote this document in preparation for what was to be one of the meetings of the colonial consultative bodies that met a couple of times every year. And he sent it to a colleague, Martez, who he thought would be attending that meeting. I don't think Martez ever received the document because, sure enough, the French secret police, the Sûreté, intercepted the document, translated it and sent it off to Maxime Léger, who was the judicial advisor, who was in charge of overseeing the Cambodian courts, the judges and the lawyers. So Penn Newt's criticisms were wide-ranging, and I think most of them were quite justified, but I want to concentrate on just two or three. Firstly, he complained that the French were writing laws and imposing legal codes without consulting Cambodians, particularly lawyers like himself. Secondly, he said it was unfair, unjust, that the majority of the population, the ethnic Khmer majority, were subject to at least two sets of laws, depending on the ethnicity of the other parties in each case. I would argue that there were three separate jurisdictions, so in fact, Khmer people could be subject to three different sets of laws. And the third one, which I will get to, I hope, was the constraints that were placed on the practice of lawyers. So the first issue regarding the ways that laws were drafted under the protectorate reflected that since 1912, and even before that, the legal codes of Cambodia had been completely rewritten. In the first round, there had been actually joint drafting committees because the French were treading very warily. They knew that they were impinging on some of the privileges of the Cambodian elite, so they had to go through the process of working with them to get their consent. However, that time had long passed by the time Penn Newt wrote his complaints, and the judicial advisor, Maxime Léger, who was meant to deal with Penn Newt's very subversive document, had himself recently single-handedly drafted codes of civil and criminal procedure for Cambodia. Although these codes were derived largely from French law, as Pip said, the protectorate authorities and the king maintained this legal fiction that instead of doing away with the old pre-colonial laws, they had actually just been modernised, that these new laws had also emanated from the king. It was a fiction that suited both the Cambodian elite and the French, because they could then claim justification for rewriting the country's laws by saying that, in fact, they were working in the name of the king. So when Léger read Penn Newt's outrageous suggestion that in drafting laws for his country, Cambodian people should actually be consulted, Léger's response was that this was absolutely impossible, because whether he knew it or not, Penn Newt was proposing a democratic principle, and that was completely against the traditions of Cambodia. So it's not unusual for the colonial state to use the idea that the people they colonised were authoritarian and barbaric to justify their own repression, but I think that was a particularly delightful example. As a result of this legal fiction that the French and the Cambodian elite and the king colluded at, the colonial law and the colonial state law never became completely secular. So that in 1947, when through a series of manoeuvres, some members of the Cambodian elite forced a very democratic constitution on the country, and a constitution that expected the king of the time, King Norodom Sihanouk, to play just a consultative role as a constitutional monarch. The French and King Norodom Sihanouk colluded again to undermine that attempt. And again, they referred to the notion of Cambodian tradition and the need to protect it and respect it. So the second of Newt's complaints focused on the fact that Cambodians were subject to different sets of laws by way of what were effectively three jurisdictions. The use of these ethnically based jurisdictions to establish colonial difference and status was a common method, I think, but it was particularly well used by the French. So by 1897, there were three different sets of laws, three different sets of courts. There were what they called the indigenous courts, where the majority Khmer population went if they were in dispute with another Khmer person. there was another sub-jurisdiction for what the French called foreign Asiatics, which was ethnic Vietnamese and Chinese. And these laws were administered by the French courts, but they were different to the laws that Europeans and French people were subject to. Cambodia was unusual because it was actually the indigenous courts that remained the most important throughout all of this process. And I argue that that came about largely because of an ongoing and very bitter dispute between the French administrators and the French colonial judges. They actually bitterly hated each other. There's a long history to that, but I won't go into the details here. So that in Cambodia, the French resident superior, particularly a man named Baudouin, worked very hard to limit the number of French judges who had the right to act in the country. In fact, there was only ever one court in the whole of Cambodia that was presided over by a French judge. Outside of Phnom Penh, the French courts were resided over by administrators, and the Cambodian courts were resided over by Cambodian judges. And so I'm arguing that it was that conflict between the two arms of the colonial apparatus that motivated the protectorate administration, and that it's a very good example of the way in which these contingent conflicts and coincidences of interest helped to shape colonial law. The third complaint was about the restrictions placed on lawyers. Pen Nut complained very bitterly that he wasn't allowed to call himself an avocat, which is the French word for lawyer. Instead, he was a métier, which is the Cambodian word for lawyer, which I think is perfectly adequate. But I think he was making the point that Cambodian lawyers, the métier, were subjected to a very draconian 1924 criminal code, which punished severely any disrespect towards an official, Cambodian or French. And the French lawyers were bound by this, which made it extremely hard for them to argue their case in court. And I don't know if many of you have ever witnessed a French-style trial, but certainly at that time, French lawyers had a tradition of, you might say, very emotional plaidoirs. They would try to convince the court, not always sticking to issues of law. And some of the colonial lawyers would use their chance to really severely go on a big rant against the colonial administration. And so the restrictions on the Cambodian lawyers were made to try to prevent them from doing that. So these are just a few examples of what you will see when you read the book, please do, of the way that law was made at that time, and making the point that law was always very important and the idea of legality was always very important, but that also in the way that it emerged was in fact a very political process and one that couldn't always be predicted. So thank you.
Professor Nicholson foreshadowed some of the things I was going to say when she was talking about the fun we had supervising Sally and the fun she had being supervised, as I could gather. This is not true of PhD supervisor relationships in general. I've supervised 20 theses, and I think none of them gave me as much pleasure as supervising Sally in conjunction with Pip. Just a few small, this is a wonderful book, and I think it was, I was very pleased to see that Pip tells people to read it. Now, that's an extraordinary thing for a supervisor to say to a general audience, but I think it's perfectly justified. It's very well written, very insightful, tells you how the French operated and why they operated the way they did. Now, two more just little vignettes. When I first came to Cambodia in 1960, was still very much in the shadow of the recently departed French administration. The language in use in the government was French. Everybody spoke French. And one could see the ministries were still, the ministries of the colonial period were still in place. And the ones that Scenic had moved into them. And then they were there when I came. This quite charming little building on the cover of the book is the Department of Justice in Cambodia, set up in the colonial era, and she has wonderful pictures of it in that period. When I was back to Cambodia in May '63 as part of an amnesty mission, we were going around trying to see about what the judicial system was going on. There were no laws in Cambodia. The law books had been torn up by Pol Pot and by the Vietnamese. But there was the Ministry of Justice. So we thought, as an amnesty mission, we should visit the Ministry of Justice. So we got our driver to take us there. We had to tell him what we wanted because he didn't know Ministry of Justice from Bar of Soap. But there was this small building, and the lot outside was a small car. At the only table I could find in the ministry was a typewriter, and the minister was out to lunch. That was the Cambodian judicial system that we had to deal with in 1963. And what else did I want to mention? Yeah, I mean, there's been a lot of interesting work on the French regime. I think I haven't read anything as thorough as Sally's examination. And it also doesn't come in with any luggage. She doesn't wave any anti-colonial flags as she writes her book. You see how the French were constrained by their own policies, how the Cambodians were kind of an obstacle in some ways. They didn't really want to be protected that much, and so on. But the French, how they operated and why they operated it emerges from this wonderful book. And on that note, I'd like to close and second this launch of this marvelous book, and I hope you all will read it. Thank you very much.
Now it's time for questions. So if you wouldn't mind, just let me know if you'd like to ask a question, and then introduce yourself. Yes, please.
Where's the book to purchase?
I think that there's an order form here with discount attached.
Let me just add one sentence that I was going to say. There's a sentence I wanted to put into my brief talk, and that is that in my career as an academic, I supervised or co-supervised 20 PhDs. Of those, in only 3 occasions, and Sally's is one of them, where I learned more from the student than I was able to teach.
So if you would like to purchase a book, we have, we don't have the books here, but the flyers there. Were there any other questions or comments, queries, observations? Hi, so was that, see, because I'm a teacher, it means I can see every hand moving, and I like anybody who looks up or down or moves their hand. Were there any? So now everyone's sitting really still, aren't they?
Well, if people are thinking, I'd just like to acknowledge that another one of David's former students is here tonight, Professor John Tully, who's also a very learned expert on Cambodian history, and whose 2 books, France on the Mekong and Cambodia under the Tricolour, were one of, along with David's works, of course, were my Bibles when I needed to reference anything about Cambodian history. So thanks for coming, John.
So John, now that you've been picked up, would you like to make a comment?
Well, sorry, I'm very much looking forward to reading the book. So I can't comment, but knowing Sally and knowing David, I imagine that it would be a really absorbing read, and I really look forward to reading it, and I hope everyone else does.
Fabulous, thank you, fabulous. Might I suggest that we call the formal parts of this proceeding to an end? Could you help me again to thank Sally and Pip and David? It's been a very interesting evening, lots of really interesting comments. Thank you.